Hello and welcome. This might be a 2 or 3 part series because the Supreme Judicial Court's ruling today is rather lengthy. It's over 20 pages long. So I will begin reading it, but first I'd like to share some screenshots that have gone viral in the Free Karen Read community as of today, February 11, 2025. So if you have not seen them yet, I will read them here for you. This one is from Ted Daniel, who is a host on Boston 25, the same news network that interviewed Karen Read, and 6 minutes of that interview was aired after the Super Bowl. So from Ted Daniel today, he states, "New statement from Karen Read's appellate lawyer." And if you guys aren't aware, Martin Weinberg is the appellate lawyer. That's why we really only see him during the appellate proceedings. So it reads, quote, "While we have great respect for the Commonwealth's highest court, double jeopardy is a federal constitutional right. We are strongly considering whether to seek federal habeas relief from what we continue to contend are violations of Miss Read's federally guaranteed constitutional rights," end quote. From Martin G. Weinberg, attorney for Karen Read. Excellent quote from Martin, and great for Ted Daniels to obtain a statement from Martin quickly as well. And then this is the court activity from today, February 11, 2025, the Superior Court activity, and it reads, defendant's motion for admission of pro hac of Mark Betterow. And I will read this one. It's from Christina Rex, and again, it's from today, February 11. It reads, much news in the Karen Read trial today. The SJC denies her appeal, and yes, attorney Mark Betterow is being added to her defense team. In parentheses, in what capacity, it's unclear so far. Plus, I have a statement from a former juror in Read's first trial reacting to the SJC news. So a lot of news coming in today, guys. It's really great that social media exists for these reasons. Anyway, so this is from the juror, and it reads, quote, not exactly surprised, an interesting situation whereby the truth that the jury was unanimously not guilty on 1 and 3, with multiple jurors signing affidavits swearing to that, and the legal process ramifications of these facts coming to light after the mistrial was declared appear to be in conflict. SJC ruling means the legal process trumps the truth, and pulling away from the juror's statement, and the juror is remaining anonymous here, but such an excellent sentence. I'm going to read it again. SJC ruling means the legal process trumps the truth. Okay, guys, like how many times have we witnessed that in the Karen Read case? The legal process trumps the truth. How many times have we witnessed Judge Bev sit back idly while Brady violations are committed before her eyes, while evidence is manipulated and inverted before her eyes, while discovery violations occur before her eyes, and she just sits there idly, not responding, not reacting, as if this case doesn't matter to her, even though, again, she refused to recuse herself. Continuing, this juror is excellent. It reads, at the end of the day, there are lots of pieces to this blame pie from a process perspective, and we, the jury, definitely own a piece, maybe even the biggest. Although we aren't exactly professional jurors and didn't know what we didn't know, by not making it clear in the jury note that we were only hung on charges too. That was our mistake. Excellent retrospection from this juror. And it's so true, guys. And if you remember the jury interviews that Aidan Kearney had and he posted about, it was made so clear that the foreperson was dictating everything. The foreperson would not allow the other jurors to communicate with Judge Bev, and the foreperson gave them incorrect instructions, and that alone should have resulted in something greater than just a mistrial. When the foreperson is giving the rest of the jury members incorrect instructions, there needs to be a better process of correction that doesn't involve Karen Reed having to fork over hundreds of thousands of dollars to remain represented by her counsel, for a system that's clearly broken. It's not Karen Reed's fault that the Norfolk County court process is broken, and maybe deliberately so. Continuing, quote, "We also didn't know that it would immediately lead to a mistrial at that point without any further interaction with the judge. A simple clarifying question from the judge as part of any trial involving more than one count as to whether the jurors' findings of being hung are related to all counts would easily prevent the situation that has unfolded in this case." Absolutely. That's the end of her quote, his or her quote. Absolutely. Really great words from this juror, and the jury members do matter. Everything they said to Aidan Kearney after the trial was over, all of that does matter. And everything they're saying now. And remember, guys, Rule 27B, what the juror is saying here, when there's more than one count, as I have argued exhaustively in multiple videos last year, especially, I argued this in multiple videos in 2024. Rule 27B was a safeguard for multiple counts when there are multiple counts. And as I have stressed over and over again, Judge Beverly Kearney did not follow Rule 27B. And so, again, when the foreperson and Judge Bev are kind of in their own world and making up the rules as they go along, this is what happens. This is what you get. So I will read this motion from the defense to include Mark Betterow. It reads, motion for admission pro hac vice of Mark Betterow. It's dated February 11, 2025. David R. Yannetti of the Yannetti Criminal Defense Law Firm and a member in good standing of the Massachusetts Bar hereby moves to admit pro hac vice Mark Betterow so that he may associate in as counsel of record for the defendant in the above captioned matter on the following grounds. Number one, Mr. Betterow is the principal attorney in the law office of Mark A. Betterow, P.C., which is located in Carnegie Hall Tower, 152 West 57th Street, 8th floor, New York, New York. His telephone number is such. Mr. Betterow's email address is that. He is admitted to practice law in the state of New York, and his membership is in good standing. Number two, defendant Karen Reed has requested that Mr. Betterow be associated in as counsel of record in the above captioned matter. Number three, good cause exists to grant this motion because Mr. Betterow has specialized skill and knowledge in representing defendants in matters of this nature. And number six, I wonder why it skips to number six. Should the court grant this motion, I will act as co-counsel during the pendency of this matter. Going to the next page. Number seven, In conjunction with this motion, Mr. Betterell has paid the Board of Bar Overseers registration fees of $355 as required by Supreme Judicial Court Rule 315. Attached hereto as Exhibit A is the registration statement for Attorney Betterell issued by the Board of Bar Overseers. Wherefore, for good cause shown, David R. Yannetti respectfully requests that this motion for admission pro hac vice of Mark Betterell be granted. February 10, 2025, respectfully submitted, David R. Yannetti. And Certificate of Service, I, David R. Yannetti, hereby certify that a copy of the above document was served on Special Assistant District Attorney Hank Brennan via email and by first-class mail to 88 Adam C. Lally, Norfolk County District Attorney's Office, provides the address, on February 10, 2025. So it's excellent. It's excellent that Karen Reed herself requested that Mark Betterell be included in her counsel in Massachusetts, and that David Yannetti, because he's already on the case and because he is an attorney in Massachusetts, is able to welcome him on board, much like David Yannetti welcomed Alan Jackson and Elizabeth Little. So excellent. Karen Reed already had a powerhouse of legal representation, so now she's got like a mega force behind her, you know, more human than human. I am so excited for her, even though the sad news that we all received today, that the Supreme Judicial Court denied the motion to dismiss. And we are going to get into that decision by the Supreme Court right now. All right, and as I said in the beginning of the video, I may have to make a part 2 and a part 3 because this decision is rather lengthy. So it begins with a notice, and I will leave the link to this decision in the description below if you would rather read it without my commentary. And I'm viewing it in night mode because the regular white copy is more difficult for me to read. The words are a bit, they're light. They're too light for me. So this version actually helps me. So if it doesn't help you, again, I will leave the link in the description below for your convenience. It begins, notice, all slip opinions and orders are subject to formal revision and are superseded by the advance sheets and bound volumes of the official reports. If you find a typographical error or other formal error, please notify the reporter of decisions. Supreme Judicial Court, John Adams Courthouse, provides the address and the website. So SJC provides the case number 13663, Karen Reed versus Commonwealth, Suffolk, November 6, 2024 to February 11, 2025. Present, Bud, CJ, Gaziano, Kafker, Wendlant, I think Georgie's, or I don't know, Dewar, and Wolohojian. Okay, JJ. All right, continuing. Those are all the presiding judges with this decision. Continuing. Supreme Judicial Court. Superintendents of inferior courts, homicide, motor vehicle, homicide, operating under the influence, leaving scene of accident, practice, criminal, mistrial, double jeopardy, deliberation of jury, investigation of jurors, verdict, affidavit, constitutional law, double jeopardy, jury and jurors. Civil action commenced in the Supreme Judicial Court for the County of Suffolk on September 11, 2024. The case was reported by Dewar J., Martin G. Weinberg, Alan J. Jackson of California, Michael Pabian, and David R. Yannetti, also present for the petitioner, Caleb J. Schillinger, Assistant District Attorney, Laura A. McLaughlin, Assistant District Attorney, also present for the Commonwealth, Jesse Rosman, Daniel McFadden, and Michael T. Packard for American Civil Liberties Union of Massachusetts, that's the ACLUM, Incorporated Amicus Curiae submitted a brief. So remember, guys, the ACLUM even submitted their own amicus brief in support of the Supreme Court dismissing the case entirely. But again, notice how the Supreme Court didn't care. It was denied. Continuing, Georges J., the defendant, challenges the denial of her motion to dismiss after her first trial ended in a mistrial. There's number 1 for a footnote. It continues, that trial was lengthy, spanning 8 weeks of evidence involving 74 witnesses and 657 exhibits. The defendant does not contend that this evidence was legally insufficient to support a conviction on any of the charges, which would preclude retrial. Number 2. That's an interesting sentence. I'm going to read it again, guys. The defendant does not contend that this evidence was legally insufficient to support a conviction. So they're saying that Karen Reed and the defense team do not believe that the evidence was insufficient. And I beg to differ that they have been arguing the validity of the evidence this entire time. I don't know why the Supreme Judicial Court has that narrative right now. Because what they're saying is, because the defendant does not contend that this evidence was legally insufficient to support a conviction, Karen Reed is therefore not precluded from a retrial. And they leave a number 2 for another footnote. Okay, so I'm continuing. Instead, her argument focuses on whether the trial judge properly declared a mistrial and the relevance, if any, of post-trial accounts of jury deliberations. Interesting. And it's been a while, like that SJC trial, the hearing was back in 2024, in September of 2024. And a lot has happened since then, and I've forgotten a lot. I almost want to go back and watch that hearing in the Supreme Court. Because a lot has happened, and I've forgotten a lot of those details. But it just doesn't seem right that that's how they start this out already. That because Karen Reed never said the evidence was insufficient, she therefore has to be retried. And had Karen Reed said the evidence was insufficient, she may not have needed to be retried. Okay, I'm continuing with the decision here, guys. The jury deliberated for 5 days, sending progressively insistent notes to the judge about their inability to reach a unanimous verdict. In their third and final note, the jury stated that, quote, some members firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges, end quote, while others did not. They described their views as rooted in, quote, sincere adherence to their individual principles and moral convictions, end quote, and stated that further deliberation would be, quote, futile and would, quote, force them to compromise these deeply held beliefs, end quote. I'm going to come back here and read the footnotes. Number 1, although Karen Reed commenced this action by filing a petition in the county court, for convenience, we refer to her as the defendant. Okay. And number 2, the record submitted to the single justice and now before this court does not contain transcripts of the testimony or the exhibits from the defendant's first trial. Interesting. Interesting. Why was the transcript of the first trial not provided? I'm going to go back up here to reread that sentence. The defendant does not contend that this evidence was legally insufficient to support a conviction on any of the charges, which would preclude retrial. And that's what the number 2 footnote pertains to. that the record submitted to the single justice and now before this court does not contain transcripts of the testimony or exhibits from the defendant's first trial. Like, okay, they didn't submit the defense team did not submit testimony, transcripts of the testimony or the exhibits for the SJC to review. And thereby the SJC has summarized that Karen Reed is not disputing the validity of the evidence. I'm not sure I'm getting that one, guys. I can't wait until the defense responds to this, if they're going to. And as we know, as Martin Weinberg said in that statement from Ted Daniels, that he's going to keep fighting it. So I hope he does, because already that doesn't make sense to me. It's on record that the defense team has disputed the validity of the evidence this entire time. I don't know how the Supreme Court can get away with summarizing it like that. Continuing, quote, force them to compromise these deeply held beliefs, end quote. Based on this final note, the judge declared a mistrial. The defendant's motion to dismiss and this petition rely on post-trial accounts from several jurors. These accounts suggest that during the deliberations, the jury unanimously agreed the defendant was not guilty on 2 of the 3 charges and were deadlocked only on the remaining charge. The defendant argues that a mistrial was thus not manifestly necessary because the judge could have requested a partial verdict from the jury before discharging them. The defendant further asserts that these post-trial accounts show she was, in effect, acquitted of 2 charges and that double jeopardy bars retrial on those counts. This petition thus raises the question, can post-trial accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper or constitute an acquittal where the jury did not announce or record a verdict in open court? We conclude that they cannot. All right, guys, that's the SJC's decision. We, the collective judges, conclude that they cannot. As in, can post-trial of accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper? Continuing, the jury clearly stated during deliberations that they had not reached a unanimous verdict on any of the charges and could not do so. Only after being discharged did some individual jurors communicate a different supposed outcome, contradicting their prior notes. So, again, guys, as a judge with power between Judge Beverly Kearney and all these judges at the Supreme Court, they all have power, okay, guys? They all have power, with or without the backing of statutes, with or without the backing of case law, with or without the rules of criminal procedure, as we have witnessed with Judge Bev. She just does whatever the hell she wants. She can completely ignore Rule 27B, And look at how the SJC doesn't even pay attention to that. The SJC doesn't go back and review the trial to know for themselves that not once did Judge Bev say, what's your verdict on count 1? What's your verdict on count 2? What's your verdict on count 3? Because had Judge Bev done her job and followed Rule 27B, which permits her to do exactly that, to question the verdicts of each and every single count, Karen Reed would not be in the situation she is in right now, and these jurors wouldn't keep being ignored like they are between Judge Bev and the Supreme Court. So the Supreme Court is relying solely on what's documented in the court file, while they simultaneously don't go back to review the court hearings. They don't go back to review the hearing, obviously, when they make their decision. Continuing. Only after being discharged did some individual jurors communicate a different supposed outcome, contradicting their prior notes. Such post-trial disclosures cannot retroactively alter the trial's outcome, either to acquit or to convict. Accordingly, we affirm the trial judge's denial of the motion to dismiss and the defendant's request for a post-trial jury inquiry. So they deny both guys. They deny the dismissal of the charges, and they deny a post-trial jury inquiry. Judge Bev doesn't want to hear from the jury members, and the SJC doesn't want to hear from the jury members. This is hell on earth for Karen Reed. Thank God she has an excellent team of attorneys, because she's clearly up against a tsunami of corruption between the Superior Court and the Supreme Judicial Court. And I get it that Martin Weinberg has to be professional. He has to say he respects them. But coming from me, I do not respect the Superior Court in Norfolk County, and I certainly don't respect the Supreme Court in Suffolk County. You know, Suffolk County, the same county that prosecuted an innocent man for the death of another police officer, John Mulligan, back in 1993. Yeah, that same Suffolk County. You know, a history of corruption. Continuing. Background. Number 1, trial and deliberations. In 2022, a grand jury returned 3 indictments against the defendant. Murder in the second degree, GLC 265, subsection 1, count 1. Manslaughter while operating a motor vehicle under the influence of alcohol, GLC 265, subsection 13.5, count 2. And leaving the scene of personal injury resulting in death, GLC 90, subsection 24, 2A.5, 2, count 3. Trial began in April 2024 and lasted over 2 months. On the 37th day, the jury received instructions regarding the 3 indictments and 2 lesser included offenses for count 2, involuntary manslaughter and motor vehicle homicide. Before deliberations began, the judge indicated that the foreperson of the jury would be given separate verdict slips for each of the 3 indictments. The judge then explained the procedure for delivering the verdicts. Quote, after the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. Yeah. And, you know, those instructions are general, right? But again, if you remember reading Aidan Kearney's interviews with multiple jurors, and if you don't, I will leave those videos in the description below. The foreperson dictated this entire process, and the foreperson incorrectly explained to the jury members that they had to reach unanimous verdicts on each and every count, which is not what Judge Bev stated in her instruction. You know, they have to reach unanimous verdicts in order to have a verdict, but they don't have to be unanimous if they don't have a verdict, right? But they clearly had verdicts on counts 1 and 3. And notice how the foreperson did not do his job. And we all know it's a he because of the jury interviews. Continuing, I will read this footnote. The motion Number 3, the motion filed by the American Civil Liberties Union of Massachusetts, Incorporated, seeking leave to file an amicus curiae brief is hereby allowed. Okay. It doesn't matter to them though, right? They don't care that a separate entity entered this case through an amicus brief to better support Karen Read. The Supreme Court doesn't care. Continuing, the judge also instructed the jury to, quote, continue deliberating until you have reached a final verdict on each charge, end quote, and to not disclose their numerical standing or progress to anyone, including the judge, quote, before such time as you have reached a unanimous verdict, end quote. The jury then began deliberations. So that's interesting. I'm going to go back to what they're saying here. The judge also instructed the jury to continue deliberating until you have reached a final verdict on each charge, and to not disclose their numerical standing or progress to anyone, including the judge, before such time as you have reached a unanimous verdict. In this own decision, guys, in this very decision, in the Supreme Court's own decision, they are pressing the matter that the jury members were instructed to not disclose their numerical standing or progress to anyone, including the judge, before such time as they reach a unanimous verdict. So I'm saying, guys, the writing is on the wall for the Supreme Court right here before their eyes, and they still will not question the comprehension of the jury members who were dictated by the foreperson to not say anything about count 1 and 3 because they weren't unanimous on count 2. Yeah, there's no hope. There's no hope for people in Massachusetts if this is how cases go, that even when the Superior Court fails you miserably, so too can the Supreme Court fail you miserably. Continuing, the jury then began deliberations. 3 days later, after approximately 19 hours of deliberations, the foreperson submitted a note to the judge. First note that stated, quote, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict, end quote. And as we know, guys, if we remember the jury interviews held by Aidan Kearney, that first note was a lie. That first jury note was not accurate because the jury immediately decided that Karen Read was not guilty of count 1 and 3. Count 1 and 3 were, quote, off the table, according to the jury members. That was the count 1 and 3 were the first counts that the jury members decided on. So, therefore, the first jury note is incorrect. It is a false statement. We have been unable to reach a unanimous verdict. It is a false statement. There were unanimous verdicts on counts 1 and 3. And I'm sorry if I'm yelling at you guys. Again, I will leave the link to this decision in the description below and just try reading it without getting angry. Continuing, after reading the note into the record, the judge requested argument from the parties on whether the jury had conducted, quote, due and thorough, end quote, deliberations, warranting a so-called Tui Rodriguez charge. There's a number 4 for a footnote. The Commonwealth argued that the jury had not deliberated long enough, while the defense disagreed, requesting the instruction and asserting that the foreperson's use of the word, quote, exhaustive, end quote, suggested an impasse. Quote, an impasse, end quote. I'm going to read this footnote. Number 4, see Commonwealth versus Rodriguez, provides the case law and the TUI. The Tui Rodriguez charge is a model instruction, quote, given when jurors report deadlock after due and thorough deliberation, end quote. That is, quote, designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view, end quote, and provides the case law. Once a deadlocked jury receives the Tui Rodriguez charge and resumes their deliberations, quote, they shall not be sent out again without their own consent, end quote. And notice, guys, notice again how the Supreme Court of Suffolk County is relying on the literal facts of what's documented in these court filings, but they are not relying on the gray areas. What's between the lines, what the jury members actually said, what the foreperson failed to do, what Judge Bev herself failed to do. It's like, this is, the Karen Reed case is like, what can go wrong will. It's whatever can go wrong is going to go wrong. That's the Karen Reed case. Because it's like, if the prosecution and the MSP and the Canton PD implant evidence and falsify evidence and manipulate evidence, through their own corruption, they frame Karen Reed, right? And then they take it to court. That's not the half of it. Then you got to deal with Judge Bev's corruption, because she's going to be in favor of the prosecution, as she proved during the first trial. And then, if you don't agree with Judge Bev, you can try to go to the Supreme Court, but they're also going to back up Judge Bev, because look, they are actually using the same arguments that Judge Bev used in her decisions. There's not even like an element of creativity here. All of these judges are unthinking here. They make Karen Reed go around in circles. They make her continue to hit walls. They make her keep hitting walls because they're not looking at a solution. They just want to go back to the court documents. They don't want to question the corruption. They don't want to question the lack of chain of custody for virtually every piece of evidence in this case. They don't want to look at the foreperson who incorrectly instructed the jury members. And when the jury members are forced to be silent, it's a dangerous process. It's a dangerous conclusion that puts Karen Reed's freedom in peril. The Supreme Judicial Court has had since September, guys. It's February of 2025. They've had since September. They've had months to make their decision, and all they give us, all they give Karen Reed, and all they give anybody else watching this case is runaround. This is literal runaround. Okay, continuing. The judge determined that further deliberation was appropriate and instructed the jury to continue. Deliberations extended through the afternoon and resumed the following Monday morning. At 10:45 a.m., the jury foreperson submitted another note to the judge, second note, which stated, quote, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. And again, guys, for the foreperson to be so eloquent, for the foreperson to have the intelligence to pay more mind to his word usage and write eloquently, he clearly has intelligence, right? He's not stupid, right? but he incorrectly instructed the rest of the jury members to reach unanimous verdicts on each and every count, or there are no counts, there are no verdicts. And in this sentence, when he states, leading to a point where consensus is unattainable, that again is incorrect. They already had, by note 2, guys, by note 2, the jury members already had a consensus on count 1 and 3. And notice how the foreperson isn't specific. He's still vague. And notice how the Supreme Court doesn't care that the foreperson doesn't refer to which count. There were 3 counts. The Supreme Court knows it. They just mentioned all 3 counts in their decision. The Supreme Court is also not stupid. So everyone knows there are 3 counts, but look at how Judge Bev reads the notes. Look at how the Supreme Court reads the notes, both not caring that the notes are general and they do not specify which count the foreperson is referring to. And I still have a hunch that the foreperson was in on it. Or that the foreperson, because the foreperson was permitted to meet with Judge Bev secretly, like separately from the rest of the jury members. Remember, none of the other jury members were permitted to speak with Judge Bev. Remember that. And guys, do not forget that a couple of jury members were kicked out of the trial. And it just so happened those jury members were disgusted by the prosecution. Let's not forget that. And again, if the Supreme Court had any integrity, they would go back to the trial and watch it. But they put the onus on the defense, like, well, you guys didn't provide us any transcripts or any evidence to review. So I'm just saying the foreperson had the opportunity to speak secretly with Judge Bev, and Judge Bev could have given him incorrect instructions, and he passed on those incorrect instructions to the jury members. Like seriously, guys, like the foreman never once said to Judge Bev, listen, Judge, we're unanimous on counts 1 and 3. We just can't decide on count 2. We are so stuck on count 2, it's not even funny. Like, the foreperson never once said that to Judge Bev. The foreperson never specified to Judge Bev that there were verdicts on counts 1 and 3. I'm going to keep reading, and then I will have to make a part 2. Continuing, upon receiving this note, the judge again invited argument from both parties. The Commonwealth acknowledged that the jury had already deliberated, quote, in the vicinity of 22 or 23 hours, end quote. There's a footnote number 5. But nonetheless argued it was premature to conclude that their deliberations had been due and thorough. Defense counsel, however, maintained that the jury were, quote, hopelessly deadlocked, end quote, and again requested the Tui Rodriguez instruction. The judge agreed with defense counsel, noting that the jury had been, quote, extraordinary, end quote, and that she had, quote, never seen a note like this requesting to be at an impasse, end quote. Remember that, guys? Remember during the trial, Judge Bev was like, y'all are so extraordinary. Like, she was so impressed by the notes. Was she really impressed by the notes? Was she really impressed by the foreperson's eloquent wording? Or was she just happy that the foreperson was doing exactly what she told him to? You know? Will we ever know? You know? Again, Judge Bev has every opportunity to prove that she's not corrupt, but she keeps proving that she's corrupt. I'm going to read this footnote. Number 5, although the transcript does not state the precise time that deliberations resumed on Monday morning, based on prior proceedings, it appears the jury had deliberated closer to 24 or 25 hours by this point. Okay, continuing. The judge then delivered the Chuy Rodriguez instruction to the jury and sent them back to deliberate further. So I'm just going to reread this one last part, and then I will conclude this video at part 1. Because it bothers me, because we all read at the beginning of this decision that the defense team did not submit the transcript or evidence to the Supreme Court, and therefore the Supreme Court assumed that the defense was not arguing the validity of the evidence, which again is peculiar to me. I'm going to reread footnote number 5. Although the transcript does not state the precise time that deliberations resumed on Monday morning, it's like they are referring to a transcript. So they relied on the transcript. Then why do they up here say that the defense did not submit a transcript, and therefore the defense is not arguing the validity of the evidence? Right here, it reads, the defendant does not contend that this evidence was legally insufficient to support a conviction on any of the charges, which would preclude retrial. And it's got number 2 as a footnote. And if we go down to number 2, it reads, the record submitted to the single justice and now before this court does not contain transcripts of the testimony or the exhibits from the defendant's first trial. So it's like, which transcript is the Supreme Court relying on? If they're saying that the record submitted by the defense team does not contain transcripts of the testimony or the exhibits. Like, what's the point of that if down here, sorry guys, my channel is called Analyze for a reason. Down here, the motion filed, sorry, not that one. The other footnote. Right here. Although the transcript does not state the precise time that deliberations resumed on Monday morning, based on prior proceedings, it appears the jury had deliberated closer to 24 or 25 hours by this point. So it's like, did the Supreme Court have transcripts or didn't they? I don't get it, guys. I don't get it. I could be looking too deeply into it, or it could just be that the Supreme Court is as shady as Judge Bev, and not even the Supreme Court can keep track of their arguments, much like Judge Bev. I'm just saying that looks like a contradiction to me. I guess I want to know, was the Supreme Court relying on the transcripts or not? I will make a part 2. Thank you for watching.